right, it is 4:30 and I think we're all set to get started. Welcome everyone. My name is Blake Hoonan. I am the chair of the Moot Court Board. And thank you for joining us here for the Fredric C. Tausend Moot Court competition. Before we begin, I would just like to remind those joining us live on Zoom, if you could please make sure your microphones are muted and your videos are turned off for our competitors. That would be much appreciated. Thank you. So arguments in this competition have been very competitive, and we want to thank everyone who came out to compete, all of our students. Our two finalists for the 2021 Fredric C. Tausend competition are Devin Epp and David Rund. So congratulations to our two final competitors. Well done. So we're very fortunate to be able to hold this competition virtually amidst numerous barriers and limitations that this year has placed on our education and everyday lives. So we absolutely could not have pulled this out without a huge amount of effort and support from Miss Lori Lamb. So on behalf of the Moot Court Board, we want to sincerely thank you, Lori, once again for helping us put together this competition. Let's have a little virtual round of applause for Lori. Thank you so much. I'd also briefly like to mention and thank our amazing in-house competition chair, Caitlin Matthews, who you'll be hearing from in just a few minutes. Caitlin has put countless hours into this competition, and we appreciate everything you do for our organization. Finally, I'd like to recognize and thank our faculty advisor, Professor Sly, as well as all of the practitioners who volunteered their time to help judge various portions of this competition throughout the past 3 weeks. And now I will hand things off to Dean Clark, who will say a few words in recognition of the Dorr family, who I understand is joining us here tonight.
Thanks so much, Blake, and congratulations to you and Caitlin and the Moot Court Board. This is always such a wonderful event. I know our justices and judges are going to be introduced shortly, but I just want to say, with the pandemic, we look for silver linings. And one of the silver linings is that we're able to have Justice Carney join us from the Alaska Supreme Court. What a marvelous thing. So I'm really looking forward to those introductions. Part of what I want to do is talk about the namesake for this competition, Fredric C. Tausend, because not everybody had the opportunity to know Fred Tausend. He was the dean of our law school. He actually started adjuncting for us in 1975, so teaching as an adjunct faculty member. He then became our dean in 1980, and that was really quite unusual at that point. For a practitioner to become a dean of a law school. He was the dean of what was then the University of Puget Sound School of Law from 1980 through 1986. And what he brought to our law school was his understanding and emphasis. He brought a lot of things, but his understanding and emphasis on the importance of training good lawyers and how important legal writing was to that, as well as good oral advocacy. So it was during Dean Tausend's tenure that our renowned legal writing program got its start. And of course, we've been one of the top legal writing programs in the country for years. And that was through the support and recognition by Dean Tausend of the importance of those skills. He also was a champion for the underrepresented in the legal profession. So during those 6 short years when he was our dean, he also helped us start our ARC program, our Academic Resource Center, with its Access Admissions program that has helped us change the face of the legal profession in the state of Washington. In addition to being our dean, Fred Tausend was just a renowned litigator. Commercial litigation, antitrust, and dispute resolution, 5 decades. And he was a longtime partner at the law firm of K&L Gates. He's left a legacy with our law school that lives on in many different ways, including this competition. He passed away in 2018. And so I really just want to recognize and acknowledge the impact of Fredric C. Tausend on our law school. We remember him and we miss him. The second thing I want to do in these few short minutes is recognize the Fred H. and Mary S. Dorr Foundation. The foundation has been supporting this competition since 2007. It's an incredible foundation. They focus on sudden infant death research, as well as providing opportunities within education. And of course, that's where this competition fits in. We have here with us today Justice Dorr's son, Dr. Fred Dorr, his wife, Pam, their son, Eric, and their daughter, Allison. And so I want to express our deep appreciation to the Dorr family and to the Dorr Foundation for supporting this competition and providing the scholarships that we'll have the opportunity to announce at the end of the competition. It's just brought such a wonderful aspect to our competition to be able to reward these students' hard work with scholarships. So to the Dorr Foundation, thank you for your support of our law school and our students. Finally, I want to recognize the law students, their hard work. We're going to see sort of the culmination as we watch our final competitors, David and Devin, today, but a lot of students have participated in this competition. And so recognize their hard work and their skills, and also that of our legal writing faculty. As I mentioned, it's been a renowned legal writing faculty for many years. And the skills that these students will show us today is due in part to the hard work of our faculty. I want to particularly recognize our co-directors, Janet Dixon and Mimi Samuel. But please, if you'll just take a moment with me, if we could all applaud our legal writing faculty. And with that, I will turn it over to Caitlin. Thank you.
Thank you, Dean. I am going to go ahead and recognize and thank our semifinal judges from last night's competition: William F. Knowles of Cozen and Connor, Melissa Osman, a prosecutor in King County, and Rachel Tausend from K&L Gates. Tonight, our final panel of judges deserves a brief introduction before we get started. First, Associate Chief Justice Charles Johnson is the longest serving justice on the Washington Supreme Court. He was born in Tacoma and is a graduate of the University of Washington and Seattle University School of Law, where he taught a course on state constitutional law for many years and remains a distinguished jurist in residence. Justice Johnson serves as a co-chair of the Washington State Minority and Justice Commission and is the chair of the Washington State Supreme Court's Rules Committee. Next, Justice Susan Carney of the Alaska Supreme Court. Justice Carney was appointed to the Alaska Supreme Court in May 2016 after 28 years representing indignant people all over northern and interior Alaska. Justice Carney worked as an assistant public defender in Anchorage and then Fairbanks for 10 years before being hired by the Office of Public Advocacy. From 1998 until her appointment to the Supreme Court, she served as an assistant public advocate based in Fairbanks and representing clients throughout the interior and North Slope, as well as supervising the agency's Fairbanks office. She was a member of the Supreme Court's Criminal Pattern Jury Instruction Committee from 2016 until her appointment. And finally, we have Judge Dwayne L. Christopher of the Tacoma Municipal Court. He is a 1997 graduate of Seattle University School of Law. While in law school, Judge Christopher worked as an assistant to the legal writing program. In 2018, Judge Christopher was elected to the Tacoma Municipal Court bench, where he currently serves as the assistant presiding judge. Prior to Tacoma Municipal Court, he served as a judge pro tem in Pierce County District Court. Earlier in his career, Judge Christopher worked as a judicial assistant in Pierce County Superior Court for the now retired Judge Brian Tollefson. He went on to practice insurance defense litigation and later opened his own law practice representing plaintiffs in personal injury and employment discrimination cases. Judge Christopher is the recipient of the Live United Award from the United Way, as well as the Marilyn Holzman Humanitarian and the Service to Diversity Awards from the Tacoma Pierce County Bar Association. Judge Christopher is on the board of Palmer Scholars and serves as a mentor to students throughout Pierce County. Next, I will introduce Professor Soderman to give us a brief background on the case being argued tonight, State v. Kramer.
Good evening, everyone, and welcome to the case of State versus Kramer. This case involves a stabbing incident that occurred on November 1st, 2018. While the defendant, Ms. Avery Kramer, does not deny that she stabbed the victim, Ms. Vera Sherman, she does claim that she did this in order to defend her 3-year-old son, little Mario. Most of the facts in this case are contested. What is not contested is that Ms. Sherman and Ms. Kramer have a history that predated this incident. They attended middle school and high school together. Their children both participated in a Head Start program at the Bethany Lutheran Child Care Center. And Ms. Sherman's now husband, Mario Nunez, is the ex-boyfriend of the defendant, Ms. Kramer, and also the father of Ms. Kramer's son, little Mario. Now, this incident occurred in the parking lot of the Magnuson apartment complex, and Ms. Kramer claims that she was walking with little Mario to a friend's apartment when Mr. Nunez and Ms. Sherman pulled up alongside her. She claims that Mr. Nunez was verbally assaulting her, and Ms. Sherman reached over and sprayed mace in Ms. Kramer's face. Ms. Kramer then ran to her friend's apartment and was rinsing her eyes out when Mr. Nunez approached her in the apartment and began physically assaulting her. She reached into the sink and grabbed out a knife, at which point Mr. Nunez left the apartment. And Ms. Kramer then hears her son, little Mario, shout from outside the apartment, "Mom!" So Ms. Kramer runs out with the knife in hand and sees Ms. Sherman close to her son, little Mario, and with the can of mace still in her hand. Ms. Sherman, on the other hand, contends that she was sitting in her vehicle with her 2-year-old son, while Mr. Nunez was in the apartment complex talking to some friends. Ms. Sherman claims that Ms. Kramer ran toward the vehicle and screaming and shouting at her, at which point Ms. Sherman held up the can of mace and Ms. Kramer retreated back to the apartment. However, she returned with the knife, and before Ms. Sherman could close and lock her vehicle door, she claims that Ms. Kramer then opened her door and began stabbing her. To support her defense, Ms. Kramer sought to introduce evidence of Ms. Sherman's prior reputation and bad acts. Specifically, she wanted to introduce 3 witnesses who would testify about Ms. Sherman's reputation for violence in high school, about the reputation of the gang that Ms. Sherman belonged to, about a prior fight that Ms. Sherman had been involved in high school, and also about a prior incident that occurred at the daycare where Mr. Nunez and Ms. Sherman took little Mario from the daycare without the prior authorization of Ms. Kramer. Before the trial, the state brought a motion in limine to exclude this witness testimony, and the court agreed with the state. They declined to allow Ms. Kramer to introduce the reputation and the prior bad acts evidence. Ms. Kramer then proceeded to trial without the evidence, but maintained her defense of others theory. At the conclusion of her case in chief, Ms. Kramer asked the court to provide the jury with an instruction about the defense of others. The court also declined this request, and the jury found Ms. Kramer guilty of assault in the 1st degree. Ms. Kramer now appeals that conviction, and on the basis that the court improperly excluded this evidence of Ms. Sherman's reputation and prior bad acts, and also on the basis that the court violated her constitutional right by preventing her from introducing her theory of the case.
Okay, and with that, we will have our bailiffs call the room to order.
All rise. The Appellate Court of the State of Washington is now in session. The Honorable Chief Justice Johnson presiding, joined by Justices the Honorable Carney and the Honorable Christopher.
Thank you. I'll call the case of State versus Kramer. If counsel is ready to proceed, you may. The only caution I will give, since we are doing this electronically, if there is a glitch, and you see me gyrating unusually, that's a signal perhaps to stop until the glitch is resolved. So other than that, counsel may proceed.
Thank you. Good evening, Your Honors. May it please the court. My name is Devin Epp, and I represent Ms. Kramer, the appellant. I would like to reserve 2 minutes for rebuttal.
That's fine.
Your Honors, my client never had her day in court. She was denied the opportunity to tell her story to the jury, and that is why I'm here today. I'm here today to respectfully ask this court to remand this case for a new trial with 1, self-defense jury instructions, and 2, Ms. Sherman's specific act evidence and violent reputation evidence. These evidentiary errors violated Ms. Kramer's constitutional right to present a defense, and they were not harmless errors. This appeal is pursuant to Washington Evidence Rule 404 and Article 1, Section 22 of the Washington State Constitution. At trial, Ms. Kramer testified that she was sprayed with mace by Ms. Sherman, beat in the back of the head by Mr. Nunez, and subsequently hears her son scream for her outside.
Counsel, is there a disagreement between you and your opposing counsel on the standard of review and the lens we are to use on the I'll call it the evidentiary issue? Do you agree? And what is that lens that we would use?
Yes, Your Honor. For the character evidence, it would be a reviewed issue de novo because it was a constitutional violation. So appellate courts must not only review a trial court's evidentiary rulings for an abuse of discretion, but it also must consider de novo when in every case where the right to present a defense is raised and whether those evidentiary rulings violated the defendant's constitutional right. And here, that is the case. Ms. Kramer was prevented from presenting the basis of her fear, and a defendant's right is violated when he is prevented from presenting that basis of her fear. And she was precluded from testifying to her version of events during trial and prevented the jury from considering the context of the record as a whole. And this case is analogous
to Ms. Epp. She was able to testify to what happened right then, was she not?
Yes, Your Honor. However, she was not able to present the basis of her subjective fear. And this is analogous to State v. Duarte Vela, where in that case, the defendant was precluded from testifying to his basis of his fear because he knew of prior violent bad acts and a violent reputation of that defendant. And the appellate court said that it was a constitutional error because it prevented the defendant from presenting that basis and reasonableness of his fear. And likewise here, Ms. Kramer was prevented from presenting the basis of her fear that she knew that Ms. Sherman was violent in high school, that she was in that valid community, and she was an eyewitness to one of those fights, and that she also took her child, aided in the wrongful taking of her child 6 months prior. And all of those events is the basis of her fear. And
counsel, I have a question for you. In State v. Duarte Vela, in that matter, it was the threats to kill the defendant's family, correct?
yes, Your Honor, it was.
So how do the facts in this case raise to that level?
Your Honor, the facts are similar in this case because they both are relating to specific acts that were known to the defendants here. And Ms. Kramer did know and was an eyewitness to that violent fight. In State v. Duarte Vela, that defendant had heard of the threats and did not actually witness these encounters, where the defendant here actually did witness the violent fight that happened in high school. And she was also aware of that taking of the child and the reputation evidence. And the jury must weigh, and State v. Duarte Vela had stated that the jury must weigh all of the facts and circumstances known to the defendant at the time of the incident. And here that wasn't the case. So the jury was unable to hear all of those facts and all of the circumstances that were known to Ms. Kramer at that time.
But there is some limit when it becomes pretty remote. These are grown women now. They're not high school students anymore. So it's been a while.
Yes, Your Honor. However, Under 404B, when looking at that specific act evidence, we look for the relevance and probative value. And because Ms. Sherman went to high school with her and was an eyewitness to that fight, it makes that more highly probative and relevant to her state of mind because she knew what Ms. Sherman was capable of doing to her child. And she had a heightened subjective fear in that moment when she had just been sprayed with that same mace bottle that was in Ms. Sherman's hand.
May I back you up? Just kind of a clarifying question. When you first opened, you talked about the self-defense instruction. Are you now limiting it to just self-defense, or are you also including defense of her son?
Your Honor, when I refer to self-defense, I mean self-defense of others, Your Honor.
Thank you.
And in addition, this case is distinguishable from State v. Jennings, in which the defendant tried to admit a toxicology report to show that he was fearful that the defendant was on drugs. However, the appellate court denied that because it was corroborative evidence, because the defendant in that case was able to testify to his belief that he was on drugs. And in this case, it is distinguishable because Ms. Kramer was precluded from testifying to the basis of why she feared Ms. Sherman. She feared Ms. Sherman because of the suppressed character evidence, because she was an eyewitness, because she knew she was violent and was active in that community, and because she knew that Ms. Sherman had recently aided in that wrongful taking of her son. And specifically, to bring me to the specific act evidence, the trial court erroneously excluded that evidence because Washington state courts have repeatedly said that it is best to admit relevant evidence and trust the state's cross-examination to ferret out those falsities. And again, under 404B, proof of knowledge is admissible as another purpose. And here it was proof of Ms. Kramer's fear, that she was fearful for what was going to happen to her son because of what she knew about Ms. Sherman standing there, and therefore it was very highly probative. Which brings me to my next point, that the reputation evidence was also erroneously suppressed because a victim's reputation for violence is admissible when the defendant alleges self-defense and shows the knowledge of the victim's violent reputation contributed to their apprehension. And here that is the case. It contributed to Ms. Sherman's apprehension because she knew what Ms. Sherman was capable of doing, and therefore it should have been admitted because it was very relevant to this case at hand.
Ms. Epp, what if we think part of the reputation should come in, but not the other part?
Your Honor, all of the evidence should come in because all of the evidence is relevant to Ms. Kramer's state of mind at that moment. And therefore, all the evidence should have been admitted because it all is the basis of Ms. Kramer's fear and to her, and that is her constitutional right to be able to tell the jury why she was so fearful, and for the jury to know all of the facts and circumstances known to Ms. Kramer. And Ms. Kramer knew all of these instances, and therefore each piece of evidence is the basis of her subjective fear. And even if this court finds that these rulings were a harmless error or a non-constitutional error, the trial court still abused its discretion. And under this standard, it requires the defense to show that a reasonable probability that the error materially affected the outcome of trial. However, it's important to note that when a court's discretionary ruling excludes relevant evidence, the more exclusion of that evidence prejudices or articulated defense theory, the more likely the court will find that the court abused its discretion. And here, considering all of this evidence, the fact that Ms. Sherman aided in the wrongful taking of her son, that she had a violent reputation that was known in a valid community that they both were a part of, and that she was an eyewitness to a fight that resulted in the victim needing stitches and going to the hospital, is consequential in determining Ms. Kramer's reasonableness in protecting her son, and it would materially change the outcome of trial. And to my last point, Your Honors, these evidentiary errors were not harmless errors. A harmless error is evidence of minor significance in reference to the overall overwhelming evidence as a whole. And the suppressed evidence was the opposite of minor. It was the basis of her subjective fear and her reasonableness. And it makes a difference in finding Ms. Kramer's reacted in self-defense. Now, if I may move on to my other point about the jury instructions. An appellate court reviews issues de novo when a trial court refused a jury instruction as a matter of law. And the burden is quite low for the defense. The defense need only to show some evidence from whatever source in the record to raise the issue of self-defense, with particular attention to the events immediately preceding and during that act. And it is viewed in light most favorable to the defendant. And here, Ms. Kramer testified on cross-examination, volume 2, page 37, line 8. The state asked, "Now it's your testimony. At that moment in time, you were very fearful for your son." And she responded in the affirmative. "Yes, I was." She also testified, quote, "I didn't know what they were going to do. Big Mario was making threats to me. Miss Sherman had maced me, and my son was screaming. I didn't know whether they were going to do something to him or whether they were trying to take him. My first instinct was to protect my child. And considering these events immediately preceding and during this act, and viewing this evidence in light most favorable to my client, Ms. Kramer's testimony provides some evidence to support a self-defense jury instruction." And in addition to that, or for the foregoing reasons, Your Honors, the appellant respectfully requests that the court reverse and remand this case for a new trial with 1, self-defense jury instructions, and 2, Ms. Kramer's specific act evidence and reputation for violence evidence because the court erred. Thank you, Your Honors.
Thank you. Thank you, counsel. Mr. Rund.
Thank you. Good evening, Your Honors, and may it please the court. My name is David Rund, and I represent the state. Your Honors, this is a case wherein justice was served. On the afternoon of November 1st, 2019, Ms. Avery Kramer stabbed Ms. Vera Sherman repeatedly with a 13-inch kitchen knife. She was found guilty and sentenced accordingly. The trial court properly decided this case. The motion in limine was properly granted because the excluded evidence was irrelevant, not probative, and lacked proper foundation. Further, the denial of the jury instructions on lawful use of force was proper because Ms. Kramer failed to bear her burden to show that the instructions on lawful use of force in defense of others were warranted.
She didn't present some evidence?
Correct, Your Honors. My opposing counsel correctly identifies that the standard is quite low for defendants, but nonetheless, Ms. Kramer did not meet her standard for 2 reasons. One, the evidence that is in the record tends to show that Ms. Kramer was the first aggressor. And number 2, she failed to show that a reasonable person in her position would have perceived a threat of bodily harm to little Mario that would have justified her in using really any force, but especially any lethal force.
As to your first point, isn't that why we have juries? They decide which side they tend to believe?
Of course, Your Honor, that is partly why we have juries, but the court serves a very important gatekeeper role in this process. It's critically important that the court makes the initial determination whether there is both a subjective apprehension of harm and an objective apprehension of harm to support a lawful use of force instruction. Without that gatekeeping role being served by the court, then it would really be anyone would be entitled to a jury instruction on lawful use of force. Even in the case where, like this one, it simply isn't warranted. Your Honors, I direct the court's attention to State versus Walker. In that case, the defendant, it's pretty analogous in a few ways. In that case, the defendant went outside of his house, knowing that his neighbor was outside, knowing that he had had an altercation with his neighbor because his neighbor had been having an affair with his wife. He took a knife out of the drawer of his kitchen before he left his house. He proceeded to leave his property, confront the neighbor on his property, and stabbed him. Similarly, Your Honors, in this case, because we're on appeal, of course, we have to take all inferences in the light misfavor to Ms. Kramer. So let's do that. If we take all the inferences in the light most favorable to Ms. Kramer, and ignore some of the controverted testimony and some of the things that simply aren't corroborated by the other witnesses, here's what we're left with. On the afternoon of November 1st, Ms. Kramer left little Mario outside with the woman whom she was allegedly so afraid of. She went inside to her friend's apartment. She came back outside with a 13-inch kitchen knife, and she ran over to retrieve her son. Now, the trial court found, they expressly found that there was no interference. She was able to access her son without interference. Nonetheless, she ran over to Ms. Sherman, and who was, again, in her car. Even Ms. Kramer rather, testified that Ms. Sherman was in fact in her car and little Mario was outside the car. There's disagreement about where exactly little Mario was, but Ms. Kramer is very clear that Ms. Sherman is sitting inside her vehicle. And when Ms. Sherman raised the mace, as she was bound to do, seeing Ms. Kramer running over with a kitchen knife, she proceeded to stab her repeatedly. Your Honors, there's nothing in this...
Counsel, in your recitation of facts, so there was one thing that's missing, and I want to know from you if you think it's significant. Evidently, it was uncontested that some prior occasion, the victim in this case and the father took the child against the defendant's wishes and refused to return it. Was that evidence that was significant to the legal issue involved in this case?
So, Your Honor, I believe if I'm correct, I believe you're referring to the evidence that was excluded as to the incident at the daycare?
Yes.
Yes.
That did not come in.
That did not come in. That's correct. No, that doesn't really change the equation for two reasons. One, that incident was more so about Mario, the child's father, than it was about Ms. Sherman. But number two, even that evidence, had it come in, wouldn't have changed the outcome of the trial because it doesn't do anything to change the fundamental problem with Ms. Kramer's theory, which is that there is nothing in this fact pattern that would have supported her using lethal force.
Counsel, wasn't the testimony or the proposed testimony of the taking of the child from the daycare, that was just 1 month prior to this incident, was it not?
It was, Your Honor. That's correct.
And so wouldn't that go to her state of mind at the time of this assault?
It would absolutely go to her state of mind, Your Honor. It would be another fact to support her theory of the case, which she was able to present, which is that she was fearful of the threat posed by Ms. Sherman. She was apprehensive of the threat posed by Ms. Sherman. That is absolutely correct. But again, Your Honor, the fundamental problem with this case is that it doesn't justify her in using lethal force against Ms. Sherman. In fact, the facts of this case don't justify her using any force against Ms. Sherman because the court expressly found that she was able to access her child without interference. On page 29, volume 3.
Counsel, had all the evidence come in, are you arguing the result would have been the same?
Absolutely, Your Honor. That's absolutely correct.
What purposes does exclusion of the evidence serve?
Your Honor, again, the court plays a really important gatekeeping role here in ensuring that the evidence that comes in has a proper foundation and is justified in coming in. There are a couple of problems with the evidence that was excluded, and that's why the court properly excluded it. To begin, I'll start with talking about the evidence from Bremerton High School and the reputation of Ms. Sherman within the high school community. Your Honors, that evidence was plainly too remote. At the time of November 1st, at the time of the incident, Ms. Sherman and Ms. Kramer were already about 2.5 years outside of their high school graduation. My opposing counsel's reliance on Duarte Vela is misguided for a few reasons. Duarte Vela is not controlling or even particularly analogous in this case. First of all, as a preliminary matter, the court in Duarte Vela didn't even contemplate the introduction of evidence quite this old. The evidence at issue in that case was only 2 years old. Whereas, again, in this case, the evidence is at minimum 2.5, at most 6.5 years old.
But if we're talking about 2 years, the court held that 2 years under those circumstances was too remote. I don't know that it said one.
Remoteness is a very important consideration in determining whether evidence should come in. So Duarte Vela did nothing to disrupt that longstanding precedent. What the court did in Duarte Vela was saying that remoteness is but one factor that the court should consider in weighing whether or not to admit or exclude evidence. Now, the facts of that case are very particular and really not at all analogous to the facts in the present case. In that case, there was a specific threat issued against the defendant and his family. The victim specifically threatened to kill the defendant and his family. Then The victim was arrested and imprisoned out of the state of Washington, actually, I believe, out of the country, for the intervening time between the issuance of the threat and the time when he was ultimately killed by the defendant. And he was killed by the defendant because he showed up in the defendant's town, but not only in his town, in his neighborhood and on his driveway. That's simply not at all analogous to the facts in this case, where there was no specific threat that was ever issued either to Ms. Kramer or Ms. Sherman. They have this long-standing relationship, in fact, and at no point in the entirety of that relationship did Ms. Kramer ever say that Ms. Sherman had issued any direct threat against her, had issued any threat against little Mario.
Well, she did say that she was, that she helped Mario's father kind of snatch him from daycare only a month earlier.
Correct, Your Honor, but if you go back to Ms. Kramer's response to that incident, it really undercuts the notion that even she felt like there was any real threat to either her or to little Mario in that incident. The preschool alerted Ms. Kramer to what happened at the daycare, and they were going to report it to the police, and Ms. Kramer specifically said, no, don't do that. So her own actions, including later on November 1st, when she left little Mario outside with this woman she was allegedly so afraid of, undercut the idea that she had any real concern that Ms. Sherman posed this grave threat to little Mario.
You're assuming that she didn't want the police called because there was no threat. Perhaps she didn't want the police called because she was afraid it would anger Ms. Sherman even more and increase the danger to both herself and to Mario. There's just no evidence why, is there?
That's correct, Your Honor, but Ms. Kramer also did not testify as such at trial, that she was afraid that that's the reason why she didn't report, or she didn't allow the preschool rather to report that incident to the police.
Well, counsel, you heard the question I asked your opposing counsel about the lens we apply to the issue on review. And there is a disagreement, as I understand it, between what standard we're going to apply. Now, they frame the issue as a constitutional violation of the right to present a defense. And if that is correct, then we would apply a constitutional lens to that claim. I understand your argument is this is an evidentiary ruling that is reviewed based upon a discretionary basis.
That is correct, Your Honor.
Doesn't matter in this case. And why would we pick one over the other? How do we select the proper standard of review?
Yes, Your Honor. You're correct in that there is disagreement between myself and opposing counsel on this point. The proper standard of review here is abuse of discretion. It's not de novo. De novo would be the standard that would be applied if there was a constitutional error. There's constitutional error if Ms. Kramer is fundamentally unable to present a defense. That's not the case here, Your Honors, for a few reasons. First being, and most importantly, there is no constitutional right to present inadmissible evidence. The trial court was within its discretion in deciding that the evidence at issue was inadmissible. Accordingly, there's really no constitutional error here. Further, even if the evidence was allowed in, the error is harmless because it would not have changed the outcome at trial. All of the evidence taken together, every bit of testimony that Ms. Kramer proffered, really goes to her apprehension of Ms. Sherman. Granted, that does bear on her lawful use of force claim. However, she was able to present that theory already. She was able to speak to her apprehension of Ms. Kramer. All of the evidence that was excluded when the court granted the motion eliminate is more on the same theme. And again, all of this evidence taken together, even if all of it had been admitted, none of it would have justified Ms. Kramer in using lethal force against Ms. Sherman, who after all was only pointing a can of mace on her keychain. And again, she was only doing that after she saw Ms. Kramer come running toward her with a 13-inch kitchen knife. So taken together, Your Honors, the trial court did not make any errors in this case that warrant reversal. Accordingly, we asked this court to affirm the trial court's ruling. The ruling as to the jury instructions was proper because Ms. Kramer failed to bear her burden to show some evidence that she was acting on the basis of a reasonable apprehension of lethal force by Ms. Sherman against Ms. Little Mario. And the evidence was properly excluded because it lacked a sufficient basis under the law. With that, with your permission, Your Honors, I will conclude. Thank you.
Thank you, counsel. Ms. Epp?
Your Honors, I will address 2 points. First, in regard to the state's point that Ms. Sherman never in fact touched, threatened, or harmed little Mario is irrelevant in regard to providing some evidence for a self-defense jury instruction. The Supreme Court in State v. Walker stated that the imminent threat of great harm does not actually have to be present, so long as a reasonable person in the defendant's shoes could have believed such a threat was present. And here, with the suppressed character evidence, a reasonable person could have believed that Ms. Sherman, acting in concert with Mr. Nunez under the circumstances, was a threat. And second, the refusal of a self-defense jury instruction was not a harmless error. A harmless error is trivial, formal, or merely academic. Ms. Kramer's testimony is the opposite. It presents credible evidence to support her right to a self-defense jury instruction. And for the foregoing reasons, Your Honors, the appellant respectfully requests the court to reverse the judgment of the trial court and remand this case for a new trial with Ms. Sherman's character evidence and a self-defense jury instruction. Thank you.
Thank you, counsel. The case will be submitted. The court will be adjourned.
All rise. Court is now in recess. If the competitors will please follow us into the waiting room while the judges deliberate.
we're not plugged in with LinkedIn.
All right, our judges are back and ready for feedback and to share the results of this evening. So we could get both competitors. Devin, I think want to make sure your screen is on.
It says that I can't start my video because the host has stopped it.
Let's see if we can fix that.
Mr. Rund, I see.
Let's see. One moment, Devin.
Great, thank you.
There we go. Sorry about that. All right.
Caitlin, if you're host, let everyone in. I don't see Pam Dorr. I don't see.
All right, let me.
Yeah, just open up the courtroom.
Okay.
Now I see Judge Clark.
Okay, now you should be able to see folks potentially at the top of your screen. Feel free to turn your camera on if you would like, everybody.
You just give me a cue, Caitlin, when to proceed.
Yeah, go ahead and start giving feedback whenever you'd like.
Okay, good job. I'm going to start with Judge Christopher to give just some brief comments and evaluations and feedback. I appreciate the fact that the two competitors only want to hear one thing, and that is who won. But part of the history of this event and is to give some feedback. But
Sure.
Judge Christopher, if you're ready, you may proceed.
Absolutely. First, congratulations, and you both have made it this far. We made it through the Zoom session without having any cat filters. I'm not sure if you all saw that, where someone appeared before a judge and they were a cat. That was, I think, yesterday it was on, so we didn't have that mishap. This ran really smoothly. You both did a very good job presenting your cases, and I appreciate the fact that you knew the facts of the case. You also knew your case law very well. And I think that you should be proud of yourselves. You had good court presence. It's very difficult to present cases over Zoom as opposed to in person, but you were both able to adapt very well. You did speak clearly so that we could understand you, and you responded well to questions. I think that was a good thing. I think that Ms. Rund, or excuse me, Mr. Rund, you did a good job. You knew the facts of the case very well, and you stuck to your arguments, your side of the case, arguing on behalf of the state, and indicating essentially saying that all the facts were in your favor, and I think that you did a good job with that. For Ms. Epp, I think you had a very good roadmap when you started out. You did a great job, and your all of your arguments were good. You went through the cases when we asked you about certain cases. You knew those facts. You knew how to distinguish those. I think your rebuttal was good as well. The one thing, though, is on your rebuttal, wasn't necessarily your rebuttal as opposed to thinking that you're going to run out of time and you want to get all your points in. And so my advice to you would be just take your time, make your arguments, and let the judges cut you off. All right. But I think you both did an excellent job.
Great. Justice Carney.
I also was very impressed with the both of you. As you probably know, this is the first time I've participated in this competition. I'm not from Washington, and the command that both of you had of the specific cases was very helpful to me. You know, I certainly reviewed the materials that were provided to prepare, but unlike in my day job, these are not cases that I'm familiar with. Even the citations to the statutes are unfamiliar to me. So the fact that each of you did a good job tying down, and in the Jennings case, this is what happened, was extremely helpful to me. And you did it without giving any impression that, let's just make sure that hick from The Last Frontier knows what's going on. So I appreciate that very much. I was impressed, Mr. Rund, with how relaxed you seemed, which, it's a gift if that is something you come by naturally, because very few people are at ease in court, and even fewer people even want to be. The only suggestion I would make as to that is just be real attuned to what level of court you are in. When you are at the appellate court, the discussion gets somewhat more nuanced. And as Judge Christopher said, you really hammered pretty hard on the facts. But as you could tell from even Justice Johnson's questions to your opponent right off the bat, things like precisely which standard of review tend to be more of a focus at this level. Ms. Epp, you were really outstanding. It always makes me feel particularly good to see outstanding young women attorneys. I would second Judge Christopher's suggestion to just, at least in our court, and I imagine in real life in your court, you're able to see the clock. So assume that you have enough time. If the judges want to hear what you have to say, they're unlikely to cut you off in mid-word or even mid-sentence. At least in our court, we generally let the person at least finish much of that train of thought. We're not going to, give you another 5 minutes so you can give us a whole treatise on this new idea you've had on a legal theory. But keep going. Don't feel the need to rush to beat the buzzer. Well done, both of you. I'm very impressed.
And I'll echo those. I don't even remember how many times I've participated in this competition, but you'd have to dust off some history books to answer that question. But it's always a pleasurable experience for me to judge the final round. If Ms. App, if you could answer a quick question, and Mr. Rund, I'll ask you the same. Were you on brief? Were you on the same side throughout the competition, or were you off brief or off?
I was off brief last night and on brief today.
Okay, Mr. Rund.
I was on brief last night and off brief today.
Yeah, I know it's phenomenal. Both of you, I echo my colleagues' comments. The fun part and the pleasurable part is that you're the best of the best, and there's very little to draw between the two of you as far as your abilities and your presentation. You're, like I said, just a joy to listen to and to converse with. Like Mr. Justice Carney said to you, Mr. Rudd, this conversation, judges like to have a conversation with attorneys about a lot of stuff that might be intriguing or important and relevant to the issue. And it's fine quality to have. Both of you, as I said, and my colleagues have echoed, did a great job. And I think you're ready to, jump into the appellate work or the trial court. Far different than when I went to law school, and many of us went to law school. We had to learn by mistakes. But neither of you had those. But the other benefit of this competition, and what I always say to law students, is these things make a positive difference in your future. You've gone through and gained the experience of what? Trial by fire. And you have a little bit advantage to perhaps others who did not enroll in this competition. I encourage you to sign up for as many of these competitions as you can because of two things. It'll make you better lawyers and advocates, and your abilities to present an argument are going to improve. But also on your resume, you're the finalist in the Tausend competition. And if I get an application for a law clerk and I see that on one application and I don't see it on another one, that's a brownie point. So it takes a lot of time, a lot of anxiety, but it's worthwhile. Sign up for as many as you can if you have that opportunity, because it'll make a difference, a positive difference in your future. Good job for both of you. Dean Clark has got the magic envelope. Dean, it's always a pleasure.
A pleasure to see you as well, Justice Johnson. And I know our competitors are waiting, but I do need to start out by again thanking Justice Johnson, Justice Carney, and Judge Christopher. It's just so wonderful that you spend your time. We know how busy you are, helping us with this competition, helping us to provide this high quality education to our amazing students. So thank you again for being here with us. I also want to acknowledge we've had 70 or 80 people on the Zoom session and an additional 30 who watched on YouTube via live stream. So we've had just a great turnout for this competition. And wow, did our competitors live up to our expectations. So before I announce the results, David and Devin, congratulations. Absolutely want to reiterate what our justices have said in terms of your performance. We see you as lawyers, and you are so ready, even though you've got some law school left, you are so ready to go out there. And we look forward, and we will watch your stars rise as you graduate and go out and practice. So congratulations. There truly are no losers at this level of the competition, although I do need to announce a runner-up and a winner. So with that, and once I make these announcements, I would ask that everyone unmute so that they can hear our applause. So the runner-up of the Fredric C. Tausend Moot Court Competition and the recipient of a $2,000 scholarship from the Fred H. and Mary S. Dorr Foundation is David Rund. Congratulations, David. Wonderful job. And I wish we were in person so that we could shake your hand and congratulate you and we could attend a reception afterwards. But please know that you just did a fabulous job and we're so proud of you. And that means, by the process of deduction, that the winner of the Fredric C. Tausend Moot Court Competition and the recipient of a $4,000 scholarship from the Fred H. and Mary S. Dorr Foundation is Devin Epp. Join me in applauding Devin. And Devin, again, just marvelous poise, and we are all so proud of you. I also want to recognize our legal writing faculty. So Janet Dixon taught legal writing 2 to David Rund, and Sarah Rankin taught legal writing 2 to Devin Epp. So congratulations to our legal writing faculty as well. That does bring us to the conclusion of this evening. Again, thank you to our justices, to our competitors, and to all of you who have joined with us and seeing this marvelous demonstration of oral advocacy. We look forward to seeing